Both. One is apropos the question regarding the quantum of the cost of the contract, etc. A lot of people had asked me. I thought just put it in a small sheet here, and also an overview of
95% was already paid.
Yes, if you allow to see this, the cost of the contract in terms of the two components, the euro component and the INR component, it's in this document. This document. So the cost of the project as far as the euro component is 271 million euros. That's what we get here. And after paying the processed bills, which is 271 point so and so, then there is a 13 million euro, which was pending payment because of the retention money, etc. So also on the INR component, the total cost was 2,221 crores, out of which 2,095 crores have been paid in the due course of processing of bills. Then only 109 crores was the amount which remained unpaid because of retention money, bank guarantee, and all those issues. Now, if you see the second note, para number 2. So RIL's claim was 1,453 crores with all interest components, etc. Then counter claim was 10,000. The award directed to pay 721 crores and penalty later interest 178 crores, total 898. Then we are also directed to release those 371 crores bank guarantees, which we have done. So the 34 court now sets aside only one part of the award on issue number 27. And now the award amount comes down from 721 to 513 crores.
Issue number 21 was allowed by section by 34 code.
27.
Issue number 27 was considered and allowed. No,
that's right. 27 has been set aside by the 34 code. Now, therefore, today, effectively, the principal sum was 513 crores, as against 721 crores awarded by the tribunal. And then serial number 5, that note we'll see. So we have deposited 595 crores in cash and 306 crores by way of bank guarantee. And of 595, they have withdrawn 595. This 371 is lying with the registrar. That is the position as regards the cost and award.
595 represents which component?
595 they have withdrawn. Portion of it. 898 has come down to 700 and 513. Now 595 has been withdrawn. But that has been released.
By consent or by orders of court?
Orders of court. Orders of court.
Where is the order?
in orders passed under section 36.
I know, where is that order? Just give the page number. I was the last occasion I left on the point about showing those contractual transactions about that escalation and how when the actual contract was formed, there's no escalation. And I only wanted to show a couple of more pages of this, but let me make it clear that by showing all this, counsel is not trying to address the court on a appreciation of evidence issue at all. There's a gray area when counsel can play with it. And so it always knows from experience that even in a criminal matter or matters like this, when facts have to be seen in a perspective, even Supreme Court talks a lot about the facts and rewrite the facts and then say, well, for the purpose of having a perspective, we write them, not for the purpose of entering into any alternate appreciation or evidentiary analysis. But there is a problem there. I thought as an officer of the court, I must share it with the court. No fact stands by itself for the purpose of the court, because facts are presented to the court, and like we have this in the Evidence Act, what is proved is a most complicated provision in the Evidence Act. So it has got several subjective dimensions, elements, etc. So when a fact is presented to the court, then the way the court looks at it in the context of that case, and by application of certain principles of evidence, how do I draw an inference about that fact? So we talk about relevance, admissibility, so on and so forth. So the inference that can be drawn from the fact, that inference is a part of evidence. But the fact by itself stands like a table, it doesn't speak for itself. So the fact by itself means sometimes something which can speak, but something which may not speak. So this is a whole aspect of the law of evidence itself. So when I am trying to show all these facts, it is not for the purpose of asking the court to enter into any evidentiary analysis at all. All that I have shown to the court so far was say that these are the facts. There are some determinations by the tribunal, and the endeavor would be to show whether these determinations by the tribunal are on the basis of certain application of principles of law, and whether in the application of principles of law there is a patent illegality or there is a public policy issue, etc. So in that context, one has to necessarily show what exactly are the sequence of events and facts. That's what I have tried to do. Lakshmi, therefore, keep it in mind. An argument will always be, counsel for the petitioner has said, taken the court into a whole range of facts and evidentiary analysis, reanalysis, etc. I have not done that at all. I have not asked the court to say whether the court's approach to delay on both sides and say whether the court has done anything wrong. I am trying to say that by an application of a principle on the liability being imposed, I impose a liability because you are in breach of a contract. If you are in breach of a contract, how do I say you are in breach of a contract? Once I know that you are in a breach of a contract for the following factual reason, then I draw inferences. The facts and inferences are coupled, so coupled. I'm only trying to disassociate the inferences and the facts as they are. Therefore, what we are trying to show is, on the delay part of it, if there is a wrong application of a principle of law, namely, how do I bring in liability here? Do I apportion it? Do I put it here? Do I put it here? That ultimately will be a question of law. Because you're fastening liability on somebody. So that fastening liability on somebody may involve necessarily a certain view on facts. But I'm only trying to tell the court that I'm not asking the court to have a view on facts, but look at the facts themselves.
Like to
That's
put it
right.
simply,
Yes, yes.
you divided the contract into three parts: performance.
Right,
1, 2, 3.
right.
Second part
Yes,
was their obligation to perform.
that's right.
And also you showed us the total deal.
Yes, yes, yes.
From the start date till the operational
That's
date.
right.
And you tried to apportion
Yes,
the delay on their part,
Yes.
which is the second part,
yes,
with regard to the whole delay,
that's right.
and the amount of damages which has been apportioned
Yes,
for the marginal delay in your favor, which you
Yes,
said
yes.
was the first part, is so glaring that the award would be patently erroneous.
I'm grateful to that. Because I
No reasonable person could have come to
absolutely, absolutely. But
put it very simply.
very, very, very true. But I thought it's important on my part to say that because I didn't want to get into a trap which I invent for myself by arguing on an evidentiary analysis. I'm not doing that at all. I thought I'll make it very clear. You will actually have only one in CC2. I read out the terms of the contract, their letter, and then we had declined. And in the list of dates, we will show some subsequent claims and rejections by us. Before I do that, let's kindly pick up CC2 for a minute and turn to page this is whose evidence is this? This is their evidence.
Yes.
This is evidence,
Yes.
not their
But
evidence.
not, right now we are relying serial, the letters where they have given the counter offer as the source.
That's all I won't see here. This is important. This is important. It's not there. Page 162. This is an extract from the evidence given from the claimant side.
Yes.
Mhm. Let's have that page.
Yes.
It is CW1. CW. At the middle of that page, this is a deposition given by CW1.
Page 162.
162. Question number 185. Please come to paragraph 18.2 of your affidavit. Can you tell us what is the formula which you have used for this calculation? Calculations made by Reliance Infra based on RBI index as per the specified price escalation formula therein. Is there a price escalation clause in the contract? Yes. Can you show the clause? Yes. Please show the price escalation clause from the contract. Article 1 of the contract at page 003, serial so-and-so, so-and-so, correspondence serial so-and-so, March 2008 and 27 February 2008. These are all documents which emanate from their side, Reliance counter offer. Then, can you indicate the clause number which is the price escalation clause in Article 1 of the contract? Article 1, which is an integral part of the contract under the letter so-and-so mentioned in the answer 188. Is there a price escalation clause in the general conditions of contract and the special conditions of the contract? It is not there.
It's not there in the letter also.
Okay. 163.
So far 188 is concerned, this relates to the correspondence made by Reliance, their
Exactly.
representation only,
Exactly.
not from your side.
We've always said no.
Yes, yes.
That's why it's important in the list of dates. Is it here? So we see those dates from 18th of May 2007. Offer, then there are tender, then there are letters of response. So we can come to 13th of December 2007, where they say we will accept it. RIL to DVC conveying acceptance of LOA at a firm price basis without provision for compensation for delay. So, and then thereafter, again, they write to us, then 27th of February 2008, stating that the issue of compensation should be mutually discussed and agreed in case of considerable escalation in cost of construction activities. It would not be possible for RIL to work without compensation for delayed period. Then next date, 29th of February 2008, 3 letters of intent issued by DVC to RIL provided that in case of delay in handing over of land, only extension of time will be granted on day-to-day basis. Then we go on to 15th of March. RIL again says requesting that provision for compensation in case of delay beyond 3 months should be mutually discussed and agreed upon. Then we have 3 separate agreements on 6th of December 2008. These are the relevant parts of the contract. 1, contract price shall be on firm basis. Then, subject to general conditions of contract enforced in condition, the contractor shall be deemed to have satisfied as to the correctness and sufficiency of the contract price which shall accept as otherwise provided for in the contract, cover all its obligations under the contract. Then the third one is about clause 40, which says contract provision for extension of time for completion on a day-to-day basis. In the event of delay in handing over of land, no provision for compensation in case of delay. Then this is also there. This dates are also there.
Yes.
Yeah. Let's turn to a date 16th of July 2013. Before that, 1st February 2013, on the top of that, 1st February 2013, during the course of execution of the contract, RIL says seeking price escalation up to 31st of December 2012 for delay. So we write back saying on 7th of March, sorry, we don't agree with you. And on 16th of July, we write again stating that the contract is on a fixed and firm price basis with no provision on account of overrun is feasible. So this kind of even post contract stages, when correspondence between the parties show that DVC had always said price variation is not admissible under the contract, and we have not agreed upon that. This being so, that takes us me to 2 limbs of the case. So I'll try to explain it a little later, but since damages has been awarded and DVC said anything attributable to the delay in handing over land? Yes.
Yes, that is your correspondence.
That's right.
That
So
is
if it is 3 months,
2008. No, not 15.3. I think. Yes, 29/2/2008.
that's right. We say extension of time will be
Provided that
granted.
in case of delay, only extension of.
So we'll say extension of time will be admissible. 29th February. But let me proceed on the footing beyond extension of time. If the delay in handing over was so enormous and it virtually paralyzed their ability to run the contract in due course, there could be a case made out in that point of time. But which is not the case here.
Your obligation, according to you, was only to hand over the land
Right.
site. And at the last stage, at the testing stage,
Yes,
provided they made the whole thing ready for testing.
absolutely.
So by the time it was made ready for testing, there was a lot of delay in the second phase.
That's how the facts speak for themselves. So when I was referring to the damages part of it, I thought incidentally I'll link it here and come back to it later. So when I say you are entitled to extension of time, and one can say if there is an enormous delay on my part, then the court may then invoke Section 73 of the Contract Act and find out if parties have contemplated something which naturally arises in the due course of a breach of a contract as a natural result of a breach. That means with no intervening factors at all. There is a cause and an effect. And the cause and effect is not stamped by any intervening factor. 73 would apply.
Most probably I was going through one of the clause on the last occasion that there
Yes.
is a clause in your contract that in case of delay, you will be entitled to a liquidated damage.
That's right.
Specifically, it was provided.
That's true. That's true. But then we have been dislodged on that ground. Because you're not
There is
able
no
to prove
specific
468 days still.
on the other side.
That's right. So why I thought 73 may have relevance, because the 34 court and the tribunal awards damages. It fixes up a formula, whatever it is. 34 court endorses it. It talks about Section 73. It justifies, says that 73 supports the award of the tribunal. Therefore, 73 will come in only if a breach of a contract exists and a party responsible, both parties knew, I'll read Section 73 in a meanwhile, both parties knew that something will be a natural consequence. Or you'll have to straight away pick up Section 7 so that I complete reading that.
Section
73 of the
73.
Contract Act.
It's a word by word copy of Henley versus Baxendale.
That's right. In many books, I have the books on interpretation of contracts. We studied in law school, Hadley versus Baxendale, and we never forget it.
Word by word copy.
And the law of contracts is one of the most interesting subject of law in English common law growth, like the law of torts. And the nuances that are built on, somebody will say, well, there is a negligent but no estoppel. No estoppel. All that very interesting nuances. 73. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract. That means in a case where the court is able to find out who has broken the contract. Number one, compensation for any loss or damage caused to him thereby, by reason of that breach, which naturally arose in the usual course of things from such breach. Which means, after I delayed in handing over my land, the other consequences must naturally arise from that breach. But if there are other breaches, other causes, other intervening factors, you can't say whatever loss the case should them has naturally arisen in the course of such breach. Therefore, 73 contemplates a certain set of things to be fulfilled before you will apply 73. So on the facts of this case, I find it difficult to persuade myself. 73 will have a clean walk-in this case. So that I'll stop it there and show some parts of the 34 court. So once I've shown to the court that on the no escalation, there is a clear statement in the contract, and once that is so, the room for indirect invocation of a no escalation clause. Virtually the court has said, oh, there is delay on both sides, but since you are not able to explain your 468 days delay, you have given up your claim against unit number 1 delay, etc. Therefore, I find there is no negative covenant in this. Liability will therefore fasten on you. So that reasoning is a patent illegality which could not have happened on the facts of this case. So that's why I'm saying I'm not asking the court to say which fact you will take into account for the purpose of saying whether 73 would apply or a negative covenant absence would apply or not. So taking the totality, even the determination by the tribunal saying both of you are at fault, if that is the determination which runs through the entire award of the tribunal, the question of looking for any award, grant of any relief is shut out.
So this amount which they have withdrawn, you must have furnished security first for the whole award, out of which they withdrew 500
That's right. That's right.
crores. So this is not the admitted amount that the DVC admits is payable to them.
No.
Otherwise, should you win on appeal, then you would have to seek restitution of that amount.
In fact, I should be seeking that. But if the award goes, everything come back.
Condition for stay.
But then by restitution in an execution application, they have to give back the money.
No, but if the award goes, then whatever money of course, they will have to
Return
cough
the
it
money.
back.
Yes.
Whether one may call it an unjust enrichment or not, I do not know. But they have to cough it back. I'll come to Delhi. Right. Because I'm asked to cite the recent judgment of the Supreme Court in DMRC. So the curative petition where
Yes. In torts, there is
So
provision.
it's subject to
regard
lots of criticisms on either side. Welcome note and critical note.
I mean, there is an observation, both parties are at fault.
That's right.
This is in case of contract. In torts, as you see, there may be a case of contributory negligence.
Yes.
So proportionate damages is cast upon the party who has contributed.
In which case, I read out last time, concurrent delay, proportionate, apportionment
Yes,
of
yes,
delay, all that will follow. If that does not follow, then you can't say both parties are a delay, but I will hold you responsible. I will hold you responsible. Because one of my final submissions will be with the award of damages by itself is a wrong application of law. I'll come to it at a little later point of time. So we have shown these are the set of facts. Now I must take your lordships to take the tribunal's award where they say about this letter.
In your book,
3 to 2017. Where is my paper? 3 to 2017.
you see on
Yeah. Do you see? One. Please see one. Lords can just pick up CC1. Pages 8 and 9. This is that letter of 3rd of February 2017. The date is by hand at page 8, top on the right hand side, top we have the date. This letter has been relied upon both by the Reliance and also the tribunal looks at it as a piece of admission on our part. Even if I may figuratively call it as a little thorn in the flesh, but I'll try to show that it did not be necessarily
Really,
so.
this is your adjudication. Their representation and your adjudication.
Yes, yes. So what they are referring to is the court says, if you lost kindly to issue number 1. So we are talking about unit 2. I attribute a delay of 468 days. I compute 468 days as a reasonable part of the delay for my claim against you. That's what issue number 1 is about. In issue number 2, we say compensation of 10.16 crores is found to be admitted on account of so-and-so, and handing over of land, etc. So, next, in the next page, this compensation will, however, be subject to condition. Compensation will be considered as full and final settlement on this score, and so shall give firm commitment that they will not make any further claim whatsoever on this account. It's a hugely qualified statement. It is not an unqualified statement.
So it is not a terms of settlement. It is one type of adjudication from your side. Suppose
right.
a representation or claim is made.
That's right.
Before going to the arbitrator, they make a representation before you.
Yes.
Which you decided citing the reason.
Very well.
This is which you cannot say it's a proposal for terms of settlement. It is a decision
But
from your
this
side.
letter has figured very prominently in the analysis
it is given
of
the
tribunal.
reasons.
That's right. Now, what am I asking the court before the tribunal? What could I have said? I could have said number 1.
No,
This is not an.
this decision by you is itself taken as an admission on your part, perhaps,
That's true.
because it is taken by the organization,
It's an offer.
by one of the parties to the contract.
It's an offer in the sense. Now, therefore, your lordships know that both many property disputes, so there's always an offer, a compromise, a settlement.
It's separate. But you see, before the state authorities or the undertakings, normally when something is made, it is duty to consider and decide by giving
That's
the
true.
reasons.
Let me.
Even the possible opportunity of being heard.
That's right. That's right.
So whatever you have done.
Without that, let me take it on the same lines. So I don't want the court to say, I'll read this letter in this way or that way as a analysis of facts. I'm not asking the court to look into any facts here at all. I look at the letter here. There are some terms of compromise, terms of settlement. And I say that will be reasonable in my understanding. I also appreciate my liability, so on and so forth. So in the context of a letter like this, what is the principle of law to be applied? The principle of law to be applied is it a settlement or a compromise? Is it unqualified? Is it unequivocal? And then if it is an admission or something which you say voluntarily brought into it, can you resile from it? Therefore, can there be an estoppel? All these principles of law will come in. I pick up only one principle, one or two principles of law here. And if on both those principles of law, the tribunal is wrong and has misapplied the law, then the 34 court endorses it. And there is a patent illegality.
So sometimes it so happens there is no arbitration clause. On the basis of this representation, you have to decide.
That's right.
And this decision is challenged in read jurisdiction. It may so happen.
You're right.
So it is just an order. You have to treat it.
Absolutely. So therefore, this is like a pre-contractual or a post-contractual breach. There are cases and cases where parties try to buy peace. So I want to buy peace. It's an offer, and by offering it, I want to buy peace. So the law in this regard, the courts, the tribunal and the 34 court almost comes close to saying there is an admission on your part regarding delay in handing over land. And they pick up only this particular part of this letter, namely issue number 2. And once you have admitted that you will have hand over a part with so much of money for handing, delay in handing over. So therefore, nothing more needs to be shown for either mulcting you with damages or for saying that you are responsible for delay. So the court looks at it as an admission. It's a pre-adjudication stage. So at a pre-adjudication stage, or even in the course of adjudication, parties do negotiate. Courts often say, why don't you go and compromise? So whatever, now the whole law of mediation stands in an entirely different philosophy. There we give up everything. We don't talk about rights, claims, and interests. So it's in a different footing altogether. So I just want to,
Specifically mentioned in the.
yes. So just see, I read issue number 2 once again. A compensation of so and so is found to be admitted on account of delay in handing over of land and other input by DVC against Reliance extra claim about rupees 1,550 crores, although not specifically mentioned in the contract. So it's like parties contracting out of a statute. I'm contracting out of the contract. Okay, no problem at all. Therefore, it's an offer, a settlement, a mediation, a reconciliation. Now, in the context of such state of affairs,
Except he has rejected it.
and that's right, I've read it. So that's why you see, if Reliance does not make any further claim, well, we'll honor this. The only 2 judgments I want to place here in this context. Calcutta Weekly Notes. Copy. The evidence. Section 23. Calcutta Weekly Notes. Yeah, first. Paragraph 12 of this judgment, the principle of law. I mean, in the previous paragraph, that's just there is the court looks at various decisions on the question of settlements, compromises, etc. Paragraph 11, let me read para 11 also and come to para 12. That well-known decision in re so-and-so, whichever refers to me, the distinct and strong authority on what word without prejudice means. And so the report. Now, if a man says his letter is without prejudice, that is tantamount to saying, I make you an offer which you accept or not, as you like. But if you do not accept it, the having made it so have no effect at all. Then our James so-and-so arguments at the bar does not without prejudice mean, I make you an offer. If you do not accept it, this letter is not to be used against me. Then to take a decision of yesterday, say of this court, so Ajit Kumar Bose, etc., reminds me of where the offer by the plaintiff in a letter in their behalf to accept without prejudice sum of rupees 5,400 in full settlement. If paid inside of a week was not accepted, such a letter has not been allowed to be used against them with a view to pinning them down to the offer forever. Next paragraph now. That indeed cannot but be so, for that is just what Section 23 of the Evidence Act provides. Founded on the principle that desire for peace is always to be preferred to spoiling for a fight. This section lays down 2 conditions when in civil case an admission ceases to be relevant even. 1, if an admission is made upon an express condition that evidence of it is not to be given. A condition which is well met by without prejudice, meaning the use of what I commit myself to, if not accepted by you, is impermissible. 2, the existence of circumstances from which the court can infer that the agreement of the parties was just so. Evidence of the admission should not be given. Since an amicable settlement of a dispute merits encouragement always, all that is said and written in the course of negotiation for such settlement appears to be nothing but proof of so many circumstances from which there should be no difficulty in spelling out the agreement of the negotiating parties of not using such statements of writings and evidence. And in sum, all that is said and written during such negotiation is generally without prejudice by the very mandate of Section 23, no matter whether those 2 words, without prejudice, or made use of or not. A rule as this rests on good sense. And for such rule, nobody could have ventured to attempt an amicable settlement, never too sure when the other fellow would trip him up for pressing into service a statement here or a statement there, conceded only for the sake of peace. Very persuasive words. You're given the copy. This is Allahabad?
This is Allahabad. 1936.
Yes.
Year 19. Para 3.
Then there's one more judgment. There are a number of judgments. I thought I'd just show a few of them. And this is AR 1936, Allahabad 157. In paragraph 3. No. That's all.
3.
That's all.
It's the bottom of page 158. 158 and 4. In the hard copy.
Yeah. The running page of the report at page 158, paragraph 3, at the bottom of page 158. There's a sentence which begins, the defendant also called Vakil Pandit Bihari Lal Sharma, who gave evidence corroborating that given by the, you'll also have that sentence. Page 158, para 3, about 15 line.
Yes, para 3.
Para 3.
Para 3 towards the end.
Para 3 towards the end. That's page 158.
No. Let the page.
Okay. Para 3 at the end, there's a sentence, almost the defendant also called Vakil Pandit Bihari Lal. You have to have that sentence. Unfortunately, some of the old report do not have placitum, like SCC has that. The defendant called Vakil Pandit Bihari Lal Sharma, who gave evidence corroborating that given by the defendant himself, in our judgment, the witness's evidence was not admissible. Negotiations were being conducted with a view to settlement, and that being so, we are bound to hold that those negotiations were being conducted without prejudice. In such circumstances, it is not open for one of the parties to give evidence of an admission made by another. If negotiations are to result in a settlement, each side must give away a certain amount. If one of the parties offers to make something less than what the later claims legally until so and so. Otherwise, persons could not make offers during negotiation with a view to a settlement. Yeah, show me the tribunals award and the 34 court vote.
CC5.
Give me CC5. Where are they? Let's say number. No.
32. Page
Page
32.
number 288. No, on this letter.
No.
Award. It's a couple of pages. Or we can straight away go to the judgment.
295.
Let me first take the court to what the 34 court has done and say why perhaps that's a blanket endorsement of what the tribunal, the way tribunal dealt with this letter and the whole issue in CC5, what page on this letter?
I have the.
The discussion by the 34 court begins at page 288.
কটা ঘাট আছে উপরে?
Paragraph 7.5.1.
Yes, CC5.
Yes, yes.
Page 2.
It begins at page 288.
আমার কোনো অসুবিধা নেই।
CC5
সব পড়ে যাচ্ছে।
side থাক,
In fact, several judgments were cited before the 34 court on this with reference letter. I read only two of them. And para 7.5.1, that's how the court begins to address this question. It says the letter dated February 3, 2017 lies at the center of the arbitral award dated 21st December 2019 and also the challenge against the said award before this court. Hence, it's crucial to deal with the challenge against the validity of the letter dated so-and-so before dealing with the challenge against the arbitral award. So, in the succeeding paragraphs, court deals with, subsequent paragraph, the court deals with the judgment cited to show that this letter could not have been treated as an admission or could not have been brought into evidence. And then kindly turn to page 295.
295.
After the quote from the judgment, an Orissa judgment, the 34 court says, however, just about para 7.5.9, however, the said judgment could be easily distinguished on the basis that there is no such condition which is explicit or implicit in the said letter dated so-and-so written by the petitioner. That means the without prejudice. So the law is, it is to be inferred from the way negotiations are entered into. You don't have to write it there. It has to be inferred there. The moment there is a negotiation and settlement, it's always without prejudice. That's what the Calcutta Weekly notes very beautifully.
You see, if you
Yes.
take it in this way also, for example,
Yes.
in case of suit against the state government or central government, section 80 CPC notice or representation, as you may say, is given. Now, after considering the representation, this type of orders are passed. Just the order which you. So, what it will be treated? Can it be placed in the suit court? In suit, can this be relied upon? Whatever basis. Let me put it like that to answer your lordship. Section 80 notice. I understand. Suppose there is section 80 notice, I say no. And whatever language you use. Correct. This is how I want to respond to your 80 notice, and this. Therefore, can a civil court, let us say, let's not go to a writ court. Yes. Let's say a civil court. Yes. Can it give a declaration that your response was illegal? The section 80 notice comes. I say, no, this is my offer to you. This offer, can the court say it's illegal in a civil court? Yes, whether reply to section 80 notice is an offer or not. It's an offer. That is the question. And we are just testing the proposition. So even in a case where it is like that, the court will say it's an offer. So an offer is not a
something which I bind to myself. That's why it's very, very, it's a qualified statement. If you do this, and if you don't claim anything further, so on and so forth, it's so qualified that you can't read it in isolation.
It's not an order.
I just come to. So,
or when negotiations are going on between the parties or their learned advocates, it should not be held on to any statement made during such negotiations.
That's what I'm saying. I could not be held on to it.
It will never proceed.
I could not be held on. I could be held on to it only if at all. If at all. Suppose, let's say we're talking about a writ court, there's an administrative law, decision taken by me. So what will the writ court do? I'll pick up only para issue number 2 and hold it against me. Suppose I only simply unqualified way stated, there's a delay on my part, I'm giving you 10 crores.
Yes, if that order is challenged in the writ jurisdiction, that particular letter which you are treating as a settlement notice.
Correct.
If that is challenged in writ jurisdiction.
I'm coming. But that letter is not only one aspect. It's got several aspects.
Yes.
So you can't say suppose I said that issue number 2 is the only response by DVC. Then the writ court say, you said you were offering. But I could say it was an offer even in the course of a negotiation. Even a writ court cannot issue a mandamus. A writ court will issue a mandamus only if there is a pre-existing legal right which can be enforced. So a settlement offer is always in the air.
No, but if you say that it is a tentative statement,
absolutely tentative.
Pending negotiation,
absolutely tentative.
Then you are not bound by it. But then, if after negotiation you take a considered decision, yes, after negotiation, I say that so much of liquidated damages is payable, then you may be bound.
Very true. Suppose after this letter, RIL has come back to me and said, we take this 10 crores. We settle it. Then we resile from that statement. One could say, well, there is something, what one call bad faith on your part, which has not happened at all. It's not. It's so tentative in it, so qualified, that it can't be given any status as a decision in administrative law, nor an offer to be bound by it in a civil court. Absolutely tentative. So therefore, this letter, I say, ask myself a question, what principle of law will you apply for reading this letter? Now, let me go a little further. There is a reliance at page 296, 297 on a Supreme Court judgment in Murugesan, that approbate and reprobate, etc. After a lengthy extract from the judgment, page 303. When we talk about approbate and reprobate, there is a doctrine of election, then there is a question of estoppel, all that gets rolled up. But I don't think any one of those things seem to arise here. Page 303, para 7.5.11. In my considered opinion, the petitioner's arguments against the letter are nothing but an attempt to invite this court to reappreciate the evidentiary value of the letter dated February 3, 2017, which this court cannot do under Section 34 of the Act. No, I am not asking the court to have any evidentiary value. I am asking the court to have a proper principle of law to be applied to this letter.
Anyway, you see, without prejudice to your rights, this letter of yours is a good gesture on the part of your client, that they have considered your claim or representation and for some reasons.
Correct.
Okay. Whether it is a negotiation or whatever it is.
Correct.
That is subject matter to be decided.
That's true.
But it's a good gesture on the part of your client that they have considered the representation, given some reasons, before the matter has gone to the arbitration.
So therefore, inviting the court to take a perspective on this letter, is it an admission, is it binding, is it an estoppel, etc. They're inviting the court to look at the principles of law for application of the letter. I'm not asking the court to enter evidentiary value. I take it as it is. Therefore, to say that we are asking the court to enter into an evidentiary, reappreciating evidentiary value, etc., I think 34 court has gone wrong on that. I want to make sure.
Not a representation, but part of a negotiation.
You want to read that letter again? Because it's
Part of negotiation is not a representation.
so what I tried to gather as the Calcutta Weekly Note talks about buying peace. Anything said in the course of buying peace is not to be treated per se an admission, not to be treated as an estoppel, not to be treated as an administrative law decision. And it's very carefully worded. Even though the contract is silent on this, I'm still say I'm offering something for you. So the buying piece is what we try to do. If, as you also rightly put me those question, if Reliance had not gone for a claim before the arbitrator and said, now that you come with this, let us try to negotiate further. Give me 20 crores, why 10 crores? So I'll give up my claim against unit number 2, 468 days delay. Then one could have seen the end of the day. But when you go to a claim based on certain reading of the terms of a contract, where do you place this letter? The proper place for this letter for the purpose of drawing or determining the liability issue. It's not a case of taking DVC further on your offer. If it's only that, it's a different issue altogether. But I'm no liability is fastened on me.
Yes, liability cannot be fastened simply on the basis of that.
That's right.
Definitely.
That's right. And when I ask the court, will you look into this wrong application of principle of law? The court says, no, you're asking me to go into evidence. I'm not asking the court to go.
It may be a ground for consideration, but not this solely it cannot be taken into consideration.
That's right. Even a ground for consideration, maybe when the court says, you'll also know that beyond the terms of a contract, an arbitral tribunal cannot do equity. Within the terms of the contract, if there is a fair, room for fair play, joints, etc., they call it, well, they can do it. But you can't invent a ground of equity and say, here is an offer, you want to buy peace. Now I ask you to be bound by that for buying peace. In which case, what is that I said I offered? 10 crores. Show me the tribunal's pages, 3 or 4 pages. I wanted the tribunal conclusions. Okay. You said page 158. What is that?
90 they conclude. 90.
These are narrations.
Yes.
I'll just invite the court's attention to only 2 or 3 pages of the tribunal's award, one at page 90 and at page 166.
No,
31. Oh, that's a running page. The reference is available at page 31 of CC5, the tribunal's award. In view of the aforesaid, para T, held the respondent has not been able to support its claim for delay. What? I'll read that. On the part so and so as claimed by the respondent letter dated 3rd February 2017. So that the reference is there. Then you come to page number 9.
Zero.
0. Page 90, paragraph P. Page 89, page 89. So page 89, I read it out earlier. Para N.
Yes.
Yeah. Yes, mark it, please mark it once again. Page 89, paragraph N.
Page 90.
First page 89, paragraph N. Page 90 is again conclusion. Thereafter, where is it? They need the reference. Oh. From the aforesaid discussion, it's clear claimant and the respondent committed default in complying with some of their respective obligations under the contract. So which means once the tribunal reaches this finding, any material before the court on which you can reach a contrary finding and which runs into this finding, I think would also be a facet of patent illegality. Now turn to page 90, paragraph P. We have already considered the fact that in the claim letter dated 3rd February 2017, respondent has not at all claimed any delay in achieving so-and-so. Thus, even on the respondent's own showing, no delay could be attributable to the claimant, and delay, if any, is subsumed as held by us in the delay on the part of the respondent. On the contrary, as shown at the heading, issue number 2 in the letter dated so-and-so, respondent actually offered compensation to the claimant for delay on the part of the respondent achieving so-and-so, thereby admitting that the responsibility for delay in achieving the RTR of Unit 1 lies squarely on the respondent. There's a quantum leap made by the court here. It fails to recognize that the intermediary part of RIL's delay is to be wished away. Therefore, you admitted here RTR Unit 1 is primarily because of delay. Therefore, there is many wrong things which happen with the reference letter. I'm told that there is a number of places where the tribunal keeps referring to this letter, both in terms of looking at facts and drawing conclusions. So this is how I look at where the tribunal went wrong in applying a wrong principle of law, and the 34 court also followed the same wrong course in not looking at this as a mere buying piece material and which has no other value in law.
So you have referred to the arbitrator's observation as well as the court's observation.
That's right.
With regard to the letter.
Therefore, this letter, I say, has no other value in law except being an intent to show buying piece. The moment you want to pick up anything in this letter and fasten a liability, then several questions of evidence will come in. Suppose if the tribunal had not returned this finding, where both are responsible for the due delays, then the tribunal could have only gone on this piece of letter without any further evidence. Let us say for a minute. And so your letter says there is a delay on your part. Therefore, I would simply fasten a liability on you. But then once the tribunal says the delay on both parts, and then that determination completely, keeps out any further look at any of these materials. Therefore, I say this letter has no value at all.
Finished 6 months. You finished the letter, you finished contracts. And judgments that we delay.
Before I do that. Would you not just pick up one more page? I've shown it earlier, page 115. Page 115 of the tribunal. CC5.
Now, sir, with regard to the observation that there is delay on both parts,
yes,
there is no, only the tribunal has made that observation. This is not made by the court, 34 court.
34 court endorses it. It doesn't deviate from that.
But although,
it doesn't, enter a contrary finding.
But still, particular issue was set aside.
That's right. That issue was present before the court. Suppose the 34 court says, I disagree with the tribunal.
Only with regard to that issue.
That's right. Suppose they have said, I disagree with the tribunal determination that there is concurrent delay or there is delay on both sides. I find delay only on the part of RIL, one story. I find delay only on the part of DV, another story. 34 court doesn't do that. Because it endorses the tribunal's findings on all issues except
27.
Everything. That's right. 27.
Since the finding of delay has been arrived at looking at documents.
I've read out those passages of the 34 court, page 326 bottom and 327. Para 8.9.2. Which paragraph?
This is 327.
That's it. Page para 8.9.2 at page 326. Extending to page 327. In my opinion, the petitioner is misreading the award. The arbitral tribunal, as discussed, you'll also have that page, as discussed, has clearly held that even if the respondent is responsible for a delay, the same got subsumed with the larger delay on the part of the petitioner in providing land, coal, and water. Such finding has been arrived after detailed consideration of all the evidence and contention of the parties. No grounds have been made out to the petitioner which would have invited this court interfere the finding of the arbitral tribunal with respect of delay. Then in page 328, just above paragraph 9.4, the previous paragraph, the top line about 3 from the top. Let me read the paragraph. The findings of the tribunal in paragraph 14.3 of the award, page 328, top. Yes. The findings of the tribunal in paragraph 14.3 of the award shows that no delay could be attributed to the respondent with regard to CO of Unit 1. After having so held, the arbitral tribunal held, delay, if any, is subsumed in the delay on the part of the petitioner. Similarly, tribunal clearly observed the petitioner neither with the support of any document, nor by legal any oral evidence have been able to show how it had arrived at a specific figure of 468 days of delay attributed to the respondent in achieving CO of Unit number 2. And in paragraph so-and-so, the award, the tribunal observed that being a chicken and egg situation, it's impossible to conclude definitely the delay on account of claimant for the entire period as compared to the contractual schedule or even for the period of so-and-so. I think there's a complete muddling up of several issues here. This letter is therefore as a predominant place in the whole discussion. Issue number 1, we talk about 468 days. That I'm not able to prove 468 days. I've not shown any evidence. Therefore, it's held against me. Because you're not able to show 468 days, delay put against RIL is vanished. How does it happen? And I don't think the 468 days delay on my part, if I can as well give it up. Suppose I give it up. I'm arguing against myself. I give it up. But you are delayed for a long period during this intervening, And then the court will say, since you have given up, we did not enter any finding on the delay of RIL. How could that follow? You have to independently discharge your burden of showing that I am not in delay at all. The core issue was therefore the court found it difficult to reach a clear finding on whose delay is in what nature and to what extent. The court found it completely difficult, or the court did not enter into that question. That's why it showed a judgment. Your Lordship, please.
The approximate value of liquidated damages, LD, comes to 202.80. And you say in this letter,
in the letter, yes,
5% of liquidated damages is to be levied on RIL. So what is stated by you, let us take it as a tentative.
I'll just come back.
Is 5% of 212 or 212? 212.
Yes,
That is 5%.
Just one second. You're also putting on
Page 8.
8, yes.
The delay analysis.
Yes.
You say second line, and hence 5% liquidated damages is to be levied on RIL.
Correct.
On the third line, you say approximate value of liquidated damages comes to 212.80.
Correct.
So is it the whole out of which 5% or 212 represents 5%? Mr. Bose says that 212 is the 5%.
No, it talks about 5%, is it?
5%. Yes.
It's 5% of the
Liquidated damages is 5% of.
That's in terms of the contract.
Yes, and retention. This is the ceiling limit. I cannot. The delay was more than the ceiling limit, but I can claim only ceiling.
So within the ceiling limit, if there is a delay, 5%. That's in terms of the contract. Well, you can just go me that page. It's there. In the second line. That's the outer limit I could levy, 5% liquidated damages.
So this figure 212.80 is 5% or 100% liquidated damages?
No, it's the contract talks about, show me the contract. Page number, this is in CC2?
Yes.
CC2. Page number 483. I invited the attention of the court earlier on this. Please come back to it again. Ah, 483.
483 of CC2.
That's right. Beneath that tabular statement, liquidated damages for delayed execution. So liquidated damages for delay in successful completion of facilities if the contractor fails to achieve successful completion of facilities for Unit 1 and 2 within 35 months and 38 months respectively from the zero date, the contractor shall pay to the employer as liquidated damages and not as penalty, because Section 74 says penalty. A sum is calculated at the rate of 1/4 of 1% of the total contract price per week of delay for each unit. Price of each unit shall be 50% of total contract, etc. Then maximum deduction for LD. The total amount of liquidated damages for delay shall not in any case exceed 5% of the total contract price. That's how it is. So, but if it's beyond what is reasonably expected, then perhaps this may bind or may not bind. We're not getting into that question. That may not be relevant for us now because we stood by the terms of the contract. So I asked myself a question when court says the principle of evidence again to come back and the principles of law which are to be applied. I take this as a letter which binds you. Wrong. I take this as a letter where you are given up on, you're not able to explain 468 days. Therefore, you're given up on your Unit 2 claim. Because you're not been able to explain 468 days delay, then reliance is relieved of explaining everything. So 468 days delay or whatever purpose I can computed is perhaps let's say take it to a very extreme proposition. I was foolish enough to give up on 1,000 days. I picked up only 468 days. That's why I say anything in this letter, calculations, computations, anything in this letter is buying piece. So you cannot pick up one part of the letter, say you have not discharged your burden or onus, and therefore it's an inference to be drawn against you. Meaning what? Their delay is subsumed in your delay. So everything ultimately runs like this. So the river runs a wrong course. So I was inviting the court's attention at page 115, paragraph 16.1, just to complete the narration of this.
On delay. Delay, and then
Where are they? Before the court copy. Let's keep them ready. To the extent, therefore, I've taken the court building on the foundation of sectional, segmental, timelines and their breach, etc. From that, we went into the question of delay. Then who should explain what delay, etc. Then, along with it, we have the question of concurrent delay, concurrent fault. We also looked into that. Because the tribunal and the 34 court says, forget about all that. Because there is no negative covenant against the fixed price issue, we will look at it as a permissible way of reading an escalation clause into the contract. And I'll come a little later whether an escalation clause being absent, a negative clause is also not there. Escalation could not have been probably allowed. But I am taking recourse to a damages route. Tribunal says I'm going to award you damages. I'll place some judgments on the delay and come back to this question. I'm trying to connect the submissions made so far. So if in the ultimate analysis, if the tribunal says that escalation, the firm price contract issue, the escalation issue, I hold against you because there is no negative covenant. But the tribunal also does not say, once they say there's no negative covenant, they could have given an escalation, relief. The tribunal does not give a relief purely on an escalation ground. Because that would have taken the tribunal to a different...
Permissible or not?
That's right.
Permissible under, as you say, law and equity or not?
Yes, right. So then the tribunal says, I'll just come to it. That's why I draw your attention to section 73, etc. I'll just address it. In the meanwhile, let me place some judgments on the question of delay.
Regarding
the other day, I read
escalation. Escalation.
On the question of delay. How do you look at delay? I place those two articles.
Delay by both apportionment of delay, your delay ex facie is marginal.
That's right. So
damages about it is excessive. In addition to that, no escalation clause, firm price contract, extension of the contract,
correct.
The same terms and conditions.
Correct. So I read two articles the other day about concurrent fault and concurrent.
And too much reliance on that letter, which has to be taken as something issued in the course of negotiation and not to be acted upon or relied upon, or not to be taken as a piece of admission or
That's right.
admission of liability. I think this is the.
That's right. That's right. Now, let me show those couple of judgments on this delay, apportionment or delay, etc. for the court. It's a very.
Para 2 and then para 7. Para 2
Very
is the
big difference.
yes.
This is what?
This is the years from the High Court of Queen's Bench.
Hmm.
This is para 70. Para 177.
Paragraph.
177.
In the days of elegant and shortly, briefly written judgment, sorry to cite a very lengthy judgment like this, but I'll trouble your lordships only with 2 or 3 paragraphs. We have at the beginning, para 2. Yeah, taking para 2. Yeah. Para 2.
How long this has started? Queen's Bench Division Technology and Construction Court?
It's a Queen's Bench division.
It was at the top.
That Vipin Sanghi.
No, this is the DPS judgment. Right.
177.
No, this is Ontario Supreme Court Justice, Canada.
Canada.
Yes, no, Lordship is thinking nowadays.
No, Royal Courts of Justice, Trial, London.
Right hand. No, I'm showing some of the judge.
Oh, sorry.
Just have a look.
Oh, DPS.
Yes.
Yes, DPS melody is of course.
Queen's Bench.
Yes, it's a
Technology and
trademark.
Construction Court.
Trademark.
No, it's a contract.
Now we have a neutral citation number.
No, that's not what my lord
They
is
have that.
asking.
Ajay,
My lord is asking
it is that.
that
Just have a look at the
they
top,
have started a
top left.
technology and construction court.
Oh, yes, of course.
Huh?
Yes.
top left.
It's quite some time now.
I didn't know. I
Top,
mean,
top left, have a
yes. I that's why I was saying.
look.
Technology construction court.
It's like a commercial court, sir.
Oh, so
It's been quite
can I
some
get a
time.
copy?
I wonder for a country like England, they could have a court like this. Why not for India?
Can I please get a copy? Can I get a copy, please? Okay.
You give it to me. I'll read. You have a
No.
copy. I'll read from my.
No, sir. I mean, they will give it later on. Later on, they'll give it.
I probably I can be a little soft on my soft copy with the reading.
It's okay, sir. I'm not addressing any.
No problem.
Your juniors will give it later. It's okay.
Yeah. Paragraph. No, let's first read para 2 and then para 10, para 9. Yeah. Paragraph 2. In about
Technology.
para 2, I think pagination would have been a.
They have the same copy as you.
I know, but then flipping through pages. In about May 2006, DB entered into a joint sales agreement for 5 years with the government of the Republic of Botswana, which included an undertaking for DB to move a major part of its operation, in particular what is known as the aggregation process, to Botswana. Although it's not clear whether these obligations are contractually binding, these undertaking came about partly because Botswana produced 25% of the diamonds handled by DB and partly because DB wished to make a contribution to the economy of the Republic of Botswana. This transfer of operations would involve the development of a software system to support the diamond supply chain management, and DB decided also take the opportunity at the same time to upgrade the existing software system, which were out of date and often differed from the department to department. Therefore, we are talking about a software system, which is the subject of a contract. Then turning over to paragraph 8.
You show me from here. Give it the copy, please. No, no. It is not done. It's not done. You got it?
We got it.
So by a letter dated 21st May 2008, Atos claimed that the progress of the work had been delayed and obstructed by the lack of cooperation from DB and by very significant increase in the scope of the work. And that unless DB agreed to renegotiate the contract, Atos would suspend all further work. Also relied on the non-payment of the fourth invoice. Although DB's request, the deadline was extended to 6 June 2008. DB was not prepared to negotiate on those terms, and Atos suspended work at the end of the first week in June. The work was never resumed. So even in a story like this, how do you look at it? Here we have a different story. Work came to a completion. In these proceedings, each side is asserting the termination was the result of a repudiatory breach of a contract by the other which it is accepted. Whichever is right about this essential issue in this case, depending on the outcome of that issue, there are consequential and different issues of causation and quantum of damages. Both sides claim substantial sums.
176.
We can skip good part of the judgment because we are not concerned with the facts. At paragraph 170, one minute. I'll read a couple of paragraphs to give a perspective on this case. Please turn to paragraph 171. In addition, you'll also have that paragraph 171.
Paragraph 171 of CC?
Same judgment.
Same judgment.
At the top of that page, 1 minute, I'll just come to it. A quick look at paragraph 169. In the previous paragraphs, they talk about some delay attributable to one of the parties. That's how they proceed in paragraph 169 like this. This conclusion renders it unnecessary to consider other causes of delay for this purpose because they were, in my judgment, at best only concurrent causes of delay and would therefore attract no liability in the form of liquid damages provided that they were achieved or delivered no later than delivery of the so and so. Other causes of delay have to be considered because they are relevant to any claim with so and so for loss caused by delay. Then paragraph 171. In addition, as I have mentioned, there were other causes of delay such as the delay in providing DB's finance requirement, for DB was responsible. There has been no analysis of the critical delays to the project, and so I must do my best to assess what delays were in truth driving completion of both bundles 2 and 3. Then 172 say, I consider the delays caused by the need to introduce workflow engine. These are analysis of the facts of that case. Then kindly come to paragraph 176. I conclude, therefore, at least so far as bundle 2 is concerned, that both splitting and causes for which Atos was responsible were driving the completion date. In other words, each party was responsible for critical delays to completion that were operating concurrently. I stand here, wait here for a minute, and say, on the facts of this case, the court says each was responsible for critical delays. I say on the facts of this case, we were not responsible for the critical delay. The critical delay means they intertwined, one intertwined with the other. So one causing the other. So that's very important. Then paragraph 177. The general rule in construction and engineering cases is that where there is concurrent delay to completion caused by matters for which both employer and contractor are responsible, the contractor is entitled to an extension of time, but he cannot recover in respect of the loss caused by the delay.
read till 170. 75% you must read. It's a scope of certain people. If you show the performance, it can give the list of
So may read that paragraph further. In the case of the former, this is because the rule where delay is caused by the employer is that not only must the contractor complete within a reasonable time, but also the contractor must have reasonable time within which to complete. It therefore does not matter if the contractor would have been unable to complete by the contractual completion date if there had been no breaches of the contract by the employer or other events which entitle the contractor to an extension of time, because he is entitled to have the time with which to complete with the contract allows or with the employer's conduct has made reasonably necessary. By contrast, the contractor cannot recover damages for a delay in circumstances where he would have suffered exactly the same loss as a result of causes within his control for which he is contractually responsible. And the conclusion of that case is 179. This means that as things stood out at the time of termination, Atos would have been entitled to an extension of time until about so-and-so, but would not have been entitled to recover from DB the prolongation cost consequent upon the delay up to that date. And just make a note of one quote by page 1, paragraph 181. 180. Thus, when considering DB's loss, to which I will turn later in the judgment, DB is not entitled to the benefit of any sum in respect of an accrued liability on the part of Atos for liquidated damages, and Atos is not entitled to a deduction in respect of any claim for prolongation cost. So that is what, if you lost to recollect, NABA says. They must lie where they are. Para 181, that is a very interesting quote there. Before I turn to consider the terms of a contract, I should remind myself of the correct approach to the construction of a term. Establish a commercial contract must be read as a whole and in the context of the events that gave rise to it. Then Riordan's speech is quoted. No contract is made in vacuum. There is always a setting in which they have replaced. The nature of what is legitimate to have regard to is usually described as surrounding circumstances. But this phrase is imprecise. It can be illustrated but hardly defined. In a commercial contract, certainly right that the court should know the commercial purpose of the contract. And this in turn presupposes knowledge of the genesis of the transaction, the background, the content, the market in the parties are operating, etc. He went on saying when one is speaking of aim or object or a commercial purpose, one is speaking objectively what reasonable persons would have in mind in the situation of the parties. So this talks about all those elements I mentioned, exclusion clause, extension time, no escalation clause, all that. So that's what parties had in mind given our situation. Then which is the other judgment?
United States going to fail.
Which paragraph?
That gives the facts. The facts. And then
Page number.
page number 11. Then next week. Page 14 bottom.
Madam, this would be more relevant in a suit. This delay and components of delay. Why is this matter you are instructing your learned senior to place all these kids?
Because we are dealing with concurrent delay. It's just the mind that when there's a concurrent delay, there's the delay gets subsumed and
If we just have to see whether there is any glaring error in appreciation of evidence, or there is no appreciation of evidence, or an appreciation is such that it takes into account of something which is irrelevant and ignores something which is relevant. Oh, these things.
That's very true. That's true. We take that. Because the number of
Which
the
Attorney General has very in detail taken us through the entire records on facts.
these judgments I thought were relevant because we always have this doubt in mind in construction contracts. And both parties blame each other. And easy to blame, but difficult to hold. So, therefore, we wanted to show this judgment that in various circumstances, when the courts are called upon to, untangle intricate facts and then inferences, how do court look at it? Therefore, more than one jurisdiction I was trying to show to the court. This was again a satellite communication operations construction. And there were delays on the part of the contract because they said our subcontractors were responsible for delay because the employer had a certain delay. So the court rejects all that conclusion. It said that as long as there is a delay on your part, and there is concurrent delay, they call it, various facets of concurrent delay. You can't put it in one particular straitjacket formula. Because depending upon the enlarging scope of public contracts and various technology dimensions, therefore, I don't think we can put it in a straitjacket formula. But the basis would ultimately be, that whether one delay is subsumed the other delay, I think I'm also beginning to have a doubt whether this subsuming can be an easy formula. Because it can happen only, my initial delay is responsible for everything else which happens later.
Combined analysis of all delays.
Yes.
You can hold one party responsible for
Correct.
it and thrust him with damages.
Absolutely.
That is it.
If my conduct
Or
after...
whether if it is one, the delay of the other party was responsible for his delay, and again in a chain reaction it went on.
That's right.
Like reciprocal promises not being performed.
Very correct.
And
very correct.
If it is not performed, then the subsequent promises also cannot be performed.
That's right.
So then you cannot saddle one party with damages and ignore the other. So
That's right.
if you balance one with the other, it will be zero.
So I think, I sum up, I'll say that this principle of subsuming being invoked here is on the facts of this case the wrong principle to be applied. The wrong principle to be applied. And that connects well with Section 73, and I also draw attention to Section 55 of the Contract Act.
You proceed on a premise of law which is erroneous, erroneous. That is the fundamental law that the arbitrator proceeds on a premise of law.
That's right.
Which is erroneous.
That's
so
right.
The whole thing becomes
that's been our endeavor. That's right. So in the first paragraph of this judgment, page 2, in this appeal, Lebelo Watch Constructor seeks compensation for costs associated with the performance of a contract to construct a satellite communication operations. The appeal includes a claim by Lebo on his own behalf and pass-through claim that Lebelo submitted on behalf of 2 of its subcontractors and Warner so-and-so. The Armed Services Board of Contract Appeal denied compensation as to all the 3 claims, and his appeal followed. We affirm. One minute. Come to page 4. This one. The court looks at delays from page 3 onwards at the bottom. But I have to deliver a circuit breakers. Then look at page 3 bottom. Additional delays continued to impact the project after the delivery of circuit breakers. For instance, Lebelo repeatedly notified Verge of his deficiencies in his work from May to December so-and-so. Lebelo also charged Enterprise with having caused delay on the project starting in May 2013, running through April 2014. In addition, it was discovered that the relays in the existing switchgear were not compatible with the new circuit breakers.
The government then obtained and furnished new relays that are compatible with circuit breakers, resulting in delay in contract completion. Another period of delay in 18 days results from issues with existing differential relays in building so-and-so, etc. Throughout the next paragraph, throughout the contract, Lebelo negotiated several contract modifications with the government to extend the completion date on the contract and to compensate Lebelo for various delays. In one of the modifications, the government compensated Lebelo for, among other things, installing new relays for the government furnished for using so-and-so. That modification included a release for all claims on behalf of the contractor and its subcontractors and suppliers for all delays related thereto. That's what we have also said in this case. Finally,
Also read page 6 bottom.
page 10.
6
bottom. Page 6. Since this was an order affirming the construction board's appeal, the last paragraph in page 6. Third, the board found that even if the subcontractor's rights were not waived, these two claims lacked merit because there was concurrent contractor cost delay throughout the relevant period. Page 6 bottom. Concurrent contractor cost delay throughout the relevant period. Specifically, the board found that 4 categories of contractor activity resulted in a total of so-and-so days delay in the project. Late finish of so-and-so, slow progress with electrical work, late commissioning of the substation, and slow progress with testing, late substantial completion as build schedule, more or less corresponding to facts of this case. So we run then to paragraph, page
14.
Page
11, the discussion starts, and it's standing at page 14.
Yeah, page 14. At the bottom of page 14, the communications from Lebelo to Wirch and Enterprise support an inference the delay attributable to the contractor continued during the 18-day period thereafter, which is important. That inference accords with the board's finding that 353 days of delay, the entirety or the period of delay in the performance of the contract, was attributable to the contractor. And we know that an appeal, Lebelo has not challenged any of the board's findings with respect to the periods of concurrent contractor delay. We therefore hold that the board's finding of concurrent delay is supported by substantial evidence. In summary, next page, the contractor contained a patent ambiguity regarding so-and-so. Then, last part of that conclusion, the line beginning, the last line at page 15. And in any event, there was concurrent delay throughout the period for which Wirch and Warner seek compensation. We therefore affirm the decision of the board. I read at page 14, I missed reading this important line, page 14, bottom. The last line again, page 14. We therefore hold that the board's finding of concurrent delay is supported by substantial evidence. Accordingly, the government was not the sole substantial cause of delay at any point between so-and-so and so-and-so. So from March...
Challenge against the order of the board. Challenge against the order of the board.
That's right. The board's order is affirmed. The board says, I deny compensation. So this intervening period, the court says the government was not responsible. We also have an intervening period of 5 years. So my delay in handing over came to an end in March 2009. The project gets completed somewhere in 2015 or 16. So all that in the intervening period in the course of execution of work, they say you found fault with my BRH, you found fault with my insulator, you asked me to do the repairs, you showed me a wrong way of doing it, all that.
Therefore, but then the question is, why did you do it at all by a defective process? So when a defect enters, all that remedial measures will certainly enter into uncertainty.
Those defects were communicated through in writing by the written letters.
We did it. I showed all those lists of dates. We had to do it. We can't say I'll take over a plant which is defective. So the very fact that there is a defective plant and machinery and which needs attention, can you probably relieve yourself an obligation to say, close your eyes to that, close your eyes to what the government should not have done, but open your eyes to what the government has wrongly done by pointing fingers at us and delaying the whole, rectification process. I suppose the delay, if any, in the rectification process, if at all, in fact, that is subsumed in the larger delay caused by Reliance during that period.
Completion means completion in a fit and usable condition.
Defect-free completion.
Defect-free completion.
That's right. I have two more connected submissions to make. Yes.
You could just read it.
Come back to 33 and show what the 34 quoted there and come to the form. Also, let's show section 55. Section this. Now, invite your lots of attention to paragraph 18.20 of the 34 court. 18.20 CC5, page 362, 18.19 and 18.20. So therefore, two stages before the arbitral tribunal. The first stage is the tribunal will have to reach a determination and enter a finding that DVC is responsible for delay. There is no delay on the part of Reliance. Every other delay, if any, is unequivocally attributable to delay in handing over land. Therefore, the claimant is entitled to, if at all permissible, entitled to invocation of a escalation clause, though it is not part of the contract. I say if at all, if it's permissible. But since the escalation clause contract itself is very hugely doubtful and is debated, and it's been declined over a period of time.
Escalation is not, you see, is silence. There is silence with regard to escalation, but there is no negative covenant.
That's why I thought
there was silence.
The non-existence of a covenant in the contract to say that you will not have escalation cost is a negative covenant. They say there is no such negative covenant. I showed to the court in every page of the contract, before and after the formation of the contract, there was this declining by DV saying, I am not giving you this escalation clause at all. So there is this clause. So the formation of a contract, the negotiation between the parties, the counterclaim which I decline, and later in the course of execution, they keep on coming back to it. I say no. So therefore, there is a negative clause. So the very fact that a counter offer was rejected means that I am not agreeing for a escalation clause. I don't have to write it in so many words. So therefore, the invocation of this aspect of the matter, namely an absence of a negative covenant, will be a good ground to grant a relief claim by the claimant. Could also be wrong for the reason that, if at all that can come, let me say if at all that can come, it can come only if there is an unequivocal finding that I am responsible for delay. In the absence of that, everything else is closed. So once that is not possible, to bring in the grant of relief by any other reasoning, that is patent illegality. That's why I wanted to come back to section 73 argument. Para 18.19 at page 362, it was argued. Justice MUKERJI has got that page?
PC5, 362.
Yes, 362. You have quoted the provisions of contract.
CC5, this is section 34 judgment. I am reading from.
Yes, section 73 is quoted, I think.
It's quoted.
Yes.
Quoted. Apart from that, what is 18.19, 20, and then. Which one? Well, let me read the paragraph 18.19 and 18.20.
Yes.
It was argued that price escalation has been granted in the garb of damages, and the award being a firm price contract, such finding of the arbitral tribunal cannot be sustained. While firm price aspect has already been deliberated in detail, but just to reiterate, the contract was a firm price contract only for the schedule of work as stipulated in the contract. In absence of an explicit prohibition, an award of escalation, arbitral tribunal was not contractually withheld from awarding price escalation. Moreover, damages have been awarded in terms of section 73. I stop here for a minute. If the arbitral tribunal was not contractually withheld from awarding price escalation, nothing prevented the arbitral tribunal from doing so. It could have said there is no negative covenant. Extension of time is only in the context of the price, firm price contract. There's delay, both parties agreed about delay, it went on. I say there is an escalation clause built into it. Therefore, I award damages or I award price escalation. Could the arbitral tribunal have done that?
Form of damages.
Therefore, if they had not, and they could not have, according to me, gone ahead with the escalation, price escalation aspect of grant of relief, then can you now say 73 and damages? Because 73 stands on an entirely independent footing. You can't dovetail 73 into a price escalation aspect. You can't bring it into it at all.
73 is a statutory provision conferring some rights.
That's right. Let's say later.
Cannot be taken away.
And I'm not saying 73 need not be looked into. I say look into 73. Look into it properly. So when you look at 73, 73 is again talking about a contract. Breach of a contract. Let me read 73 and place my submissions. Compensation for loss or damage caused by breach of a contract when a contract has been broken. Therefore, I split it into its elements. There is a contract which has come to an end. There's a broken contract, not a subsisting contract. Secondly, the party who suffers by such breach is entitled to receive from the party who has broken the contract. That calls for determination who has broken the contract. As I said earlier, compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach. That means take a case of a lift not working. So it comes down, naturally arising. You cut a tree, branches coming down, naturally arising. But where there are intervening causes, like your delay on your part. So the breach of a contract is as I said, is intervened by so many other factors. There's no question of a natural,
This
factor coming here at all.
has partially entered the contract law also, that break in the chain of causation. That is
Right.
in the criminal law, it is known
That's
as
right. That's
also in the law.
If there is a break,
is a break gone.
then 73 goes out.
It has been partly
73
Between
talks
what-
about a clear, simple situation. I have broken, my breach led to your loss, and then I am responsible for causing the delay. So this 73 cannot come in by way of a damages. It can come in by way of damages only when there is a simple picture available before the court. So to convert, therefore, two patent illegalities have occurred here. To dovetail a 73 element into a price escalation and to treat it as a substitute for a price escalation. So price escalation is not possible, but I am substituting as a way of damages. So therefore, that is also an illegality in applying a principle of law. Then what does the court say in para 18.20? That's a conclusion drawn by the section 34 court. It's a well-established principle of law that if a contract has been breached, the party who has suffered so-and-so cannot be left hanging. Section 73 of the Indian Contract Act is a statutory safeguard to protect the party of a breach of a contract in the absence of any explicit bar on award of damages in the contract. The arbitral tribunal cannot be faulted for award of damages. Even if extension of time as a result of breach of contractual obligation has been availed as a remedy, it would not prevent the party who had suffered such breach from putting forward a claim for damages if there is no explicit prohibition contained in the contract. I proceed along with this reasoning. The contract, let's say, did not have an anti-damages clause. But in order that the anti-damages clause is invoked, you will have to say that I've discharged my liability of showing that you are responsible for the breach of a contract. So the question whether such a clause exists in the contract or not becomes irrelevant on the facts of this case. So whether there is a clause against claiming damages or leaning in favor of giving damages, it becomes irrelevant. So what is irrelevant has been picked up as a relevant aspect of the matter. Therefore, the entire reference section 73 proceeds on various what called faulty legal assumptions and analysis. That takes me to one connected issue now. Yes.
How much?
That's what I'll just take about another half an hour or so. That's about all. And we'll learn it when we'll address the court on the bank guarantee, the retention money, etc. There is that.
Then shall we keep it next Friday?
Next Friday would be what date? If you can, subject to Lord's convenience, I can take a little more time and complete.
Sorry?
I thought if I can complete another half an hour, subject to Lord's convenience.
Today.
If I can complete it today.
So today you will take about half an hour.
About half an hour, I think. I should not take my, and then my learned friend will.
Then following day, not.
Is it
As my lords decide.
You can complete your submissions today.
I'll complete today.
Yes.
Whatever time would suit your lord.
So we reassemble after 2 o'clock.
Very well.
At around 2:15.
Though I would love to come back to Calcutta again.
You must.
The city of joy.
2:15.
Very well. What do you say?
এই রাম জন্মভূমি 25 সালের যেটা ওইটা সই করে রাম জন্মভূমি এই to Damodar Valley Corporation.
Before it take your lordships to the final leg of the relay race, if we put it like that. Where it relates to the question of a formula which was applied for granting damages, and they put it at 75%. Before I come to that, let me place a few judgments on how to put it in a perspective, like what Supreme Court has now, by and large, said on the following grounds: a 34 court or a 37 court, and finally a further appellate court may review it, from Associate Builders and SsangYong and all that. I want to pick up some broad principles from them and say, how are they applicable here? Counsel may also have some difficulty when we are simply talking about perversity. Because perversity, as we normally understand, is ordinarily in the context of a fact or an inference being drawn, or let's say a wrong burden being placed by somebody and all that. We call it very perverse. But in the arbitral law, because of the limitations of review by or a correction by the further courts, I think perversity will take a slightly different complexion. Because there are so much of limitations on the grounds of review, but there should be a certain flexibility within those limitations. That's why we talk about shocking the conscience of the court. So counsel may say, this shocks the conscience of the court. The court will sit back and think, has it really shocked my conscience? So therefore, it's a collection of facts, principles of law, application, invocation, all of them put together. Is there a room for justice being done to one party, which the way it has been done shocks the conscience of the court?
If according to the court,
yes,
the damage awarded is exorbitant or very high, so does it come under shocking the conscience?
That is one. That is one. But if there is a fundamental basis which is lacking for the grant of an award itself,
if the court thinks
that's a more fundamental thing which shocks the conscience.
That the award granted is exorbitant, which ought not to have been.
You're also right. But that is then a question when the claimant is entitled to something, yes, but the award is exorbitant.
Yes, yes.
That is one facet. That's one facet of a conscience being shocked. But I'm talking about something more fundamental. The very grant of a relief. It shocks the conscience of the court. Because the facts, as an independent observer, reasonable person, as SsangYong talks about, would not permit this course of action to follow, then it shocks the conscience of the court. There's a judgment of a learned single judge in the Delhi High Court, which uses this expression to unsettle an award. And that was an order under Section 33. Do you have the...
We've given the quote.
This is 2011 SCC online. We don't have a...
It's under the old act.
It's an old act.
This is under the old act, but in principle.
But Section 33 of the old act, you just look at it. Even though, for our purposes, there could be a small question, because it's in the old act, I understand the concept of shocking the conscience of the court is however, beyond the distinction between the old and the new act. Paragraph 5 of this judgment or may request the court to just
go to paragraph 3. So why is this being considered here? Paragraph 3. Now I come to the objections raised by the petitioner under claim number 1, subheads 1 to 4. These were claims made by the petitioner to claim liquidated damages. These claims are made for the following amounts on account of delay in the execution of different aspects of the work under the contract by the respondent. The various amounts are claimed. Then comes paragraph 5. The submission of Mr. So-and-so, learned senior counsel for the petitioner, is that while discussing the various claims for liquidated damages, the learned arbitrators have concluded the delay in the completion of the various stages of work was attributable to the petitioner and also to the respondent. The learned arbitrators have declined to grant the claim for liquidated damages on the basis that the respondent contractor was not solely responsible for the delay and that the petitioner was also responsible therefore. Then the contractual clauses are set out here that may not trouble the court. Paragraph 8, para 8.
The submission.
The Mr. Sani submits that is exercise of apportionment of the respective delays and defaults has not been done by the tribunal, even though from the discussion of the award is evident that the tribunal was possessed of all the materials to make the said computation. He submits that the reason for this computation not being made by the learned arbitrator is that they proceeded on the premise that unless the respondent was solely responsible for the delays, the petitioner's claim for liquidated damages could not be sustained. Sani submits that a reading of a clause in the contract which stipulates the liquidated damages paid by the contract for delay and default in execution of the various aspects of the work, along with clause 10 for the contract and so on. So, it cannot be said the liability of the respondent to pay the liquidated damages would arise only if the respondent is solely responsible for the delays and not otherwise. Now,
Para 15.
1 minute. Yeah. Paragraph 15. On the other hand, learned counsel for the respondent submit that the learned arbitrators have examined the evidence led by the parties, including the correspondent exchange between them and the minutes of the various meetings will be threadbare. On that basis, concluded that no liquidated damages were liable to be paid to the respondent by the respondent, as the obligation the contract were reciprocal, and there were delays on the part of the petition discharging his obligation. Reference is made to para 28. Tribunal, he submits. The tribunal recorded findings of fact in relation to the various subjects in the claim so-and-so. The respondent was not able to fulfill his obligation on account of the delays of the petitioner. Then the award in that case is read out. Then paragraph 19. No doubt the findings of fact returned by them with regard to the delay on both the sides would not be interfered by this court as they are based on evidence brought before them. However, that's not the end of the matter. Clauses so-and-so, etc., entitle the respondent contractor for extension of time for the period for which the petitioner has caused the delay. The liquidated damages to which the petitioner is entitled is set out in clause 10 as extracted above. The learned arbitrators have themselves returned a finding the respondent is also liable for some delays. However, the learned arbitrators have disallowed the claim for liquidated damages on the assumption that the said damages could be awarded to the petitioner only if the respondent was solely responsible for the delay. With due respect to the tribunal, there is no basis for such an assumption. The meaning of the expression delay in the context of so-and-so aforesaid would mean the delay over and above the delay for which the petitioner was responsible. That is, the total delay vis-a-vis the contractual period minus the delay for which the petitioner was responsible. As the tribunal has proceeded on the assumption that liquidated damages would be payable by the respondent contractor only if the contractor was solely responsible for delay, even though the tribunal finds the delay was on both sides, it has not proceeded to apportion the delays for which the petitioner was responsible and the delays for which the respondent was responsible. The claim of the petition of liquid damages ought to have been considered after quantification of the quantum of delay for which the petitioner was responsible and for which the petitioner was not responsible. Very important. For the sake of clarity, I may make an illustration. Supposing under the contract, a particular aspect of the work had to be completed in the span of 4 weeks, petitioner may not performing his obligation, which in turn prevented the respondent from performing his obligation, caused a delay of 2 weeks, and the said aspect of work is completed in 8 weeks, then by application of clauses so and so, the respondent contractor would be entitled to extension of time by 2 weeks. The delay attributable to the respondent would then be total time taken 8 weeks minus originally stipulated period, that's 4 weeks plus extension of time granted equal to 2 weeks. Then the finding paragraph, time was set at large and was not the essence of the contract, does not militate again the right to claim liquid damage contractually provided. Then we come to paragraph 22. As already noticed here and above, there are two erroneous propositions of law and the learned arbitrator the path in award. The first is that unless the respondent contractor is solely responsible for the delay, the petitioner could not claim liquidated damages in the contract. And the second is that time was set at large and was no longer the essence of the contract, and the petitioner was entitled to liquidated damages. In KV so-and-so, Supreme Court observed a court cannot scrutinize the reasonableness of the reasons given by the arbitrator award. I am not looking at that. So then, para 20.
Yes.
23, then I read 23, the second part of it. However, if the reasons are such that no person of an ordinary prudence could ever approve of, or if the reasons are so outrageous in their defiance of logic that they shock the conscience of the court, then it will be a different situation, and in appropriate case, the court may interfere. With due respect to the arbitrator, reasoning cannot be approved and adopted. They consequently set aside the award. So the shocking of the conscience of the court, whether under the 1940 Act or 19th Act, does not make a difference, but only the subtle difference would be that whether the shocking the conscience of the court is because of fundamental illegalities in the arbitrator's procedure being adopted and the reasoning being applied. And as I said, sometimes even an application, a wrong application of a principle of law may not be mere error of law. It will go to the root of the matter. When error of law is, sometimes I say one principle of law may or may not be applicable. The court picks up that principle and applies it. Maybe an error of law, which doesn't go to the root of the matter. So we are talking about those illegalities by reason of a wrong, fundamentally wrong approach to the case, and an illegality where having looked at the delay and not having apportioned the delay, and a third, having failed to apportion the delay, falling back on section 73 of the Contract Act, and having done that, going further in saying I'll pick up a formula and then now grant relief. So it's a chain of illegalities, one leading to another. And I'm not asking the court to look at them in isolation. If the first illegality has virtually vitiated the other illegalities, it's like the pack of cards. They fall. So the first card falls and everything falls. So it's like that. So now I come to two connected issues. 1 minute. We also can make a note of section 55 of the Contract Act.
Contract Act.
In a way, the reference to section 55 is, in a way, is
Reference to section
55. Is both a substantive issue and also I may call it a kind of a footnote to section 73 aspect. But let me read section 55, particularly the third part, but let me read the entire provision. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before a specified time, fails to do any such thing at or before the specified time, the contract or so much of it has not been performed becomes voidable at the option of the promisee if the intention of the parties at the time should be the essence of the contract. Therefore, I find after March 2009, I handed over land, 2010, 2011, 2012. So I want to now terminate the contract because you have not performed your contract in time. It becomes voidable. But I have not done that. Now we go to the second part. If it was not the intention of the party that time should be the essence of the contract does not become voidable by the failure to do such a thing uttered before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure. More importantly for us, the next part of it. If in case of a contract, voidable on account of the promisor's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than that agreed, the promisee cannot claim compensation for any loss occasioned by the non-performance of the promise at the time agreed unless, at the time of such acceptance, he gives notice to the promisor of his intention to do so. So if in 2009, when I handed over land belatedly, Reliance had said, look here, I'm going to stop my work. I can't go ahead with this. And I'm giving you a notice, one situation. But if both parties here, I look at 55 as a principle of law like this. If among both the parties, there is an agreement that both of us will have a negotiated extension of time. And if that happens, the question of parties going beyond the negotiated extension of time, parties seeking any compensation is practically shut out. So 55 is a very important principle. I can say it's voidable now, I close the contract, but you both go ahead with the contract, negotiate for the continuation of the contract, and in the meantime also negotiate for some modification does not happen. So where is the question of somebody claiming compensation at all?
No. Representation was made at the very outset that without escalation, without extra, we will not be able to work.
That's one. I am trying to look at 55
after
a broader sense.
It was over.
That's right. I'm looking.
Yes.
I'm sorry. I was trying to look at 55 in a very broader sense. It may happen at that time when a breach has occurred. I have delayed. I now call it a voidable contract.
For example, they could have. That was the time.
That's right. But then when parties, part 2 and part 3 talk about situations when parties have gone ahead with the contract. They have not called it voidable. They have gone ahead with the contract. So when we've gone ahead with the contract, unless you want to say, look here, I'm going to claim a compensation for the extension of this contract.
For the delay.
That's right. Then I must put you to notice. Otherwise, I'm going to call it voidable event. So there is a broad principle here. What I want to say is 55 says that either at a threshold or at a later point of time in the course of execution of a contract, extensions of time have been given and parties have agreed on that.
Yes, that is
right.
Admitted.
Then the question of compensation would hardly arise except in exceptional circumstances where the contractual term may itself provide. Here it doesn't provide. Therefore, even 55 in a way shuts out any inquiry by the tribunal. It shuts out an inquiry at the threshold. So where all these elements are present, 55 broadly applied shuts out an inquiry at the threshold. 73 is not invocable. So all those things which arise at the threshold are the tribunal not to get into this question of a claim at all. Then the tribunal proceeds, as I said, I say, look here, let me look at the delay and see where the road will lead us. Therefore, that's where I say the award shocks the conscience of the court. So it began on a wrong journey and ended in a wrong termination. So therefore the award is shocking the conscience of the court. Now I'll just only show some passages from Sangyong, and I don't propose to read it at great length. And before I see that, since that one last issue is still outstanding, I'm sorry, Your Lordship.
You can just refer to the legal issues in that judgment, because that judgment has been cited at least 100 times before us.
That's why I said we'll not read it. But there's one last limb which I thought I'll connect it now. In the three agreements, there are three separate agreements. One as regards the offshore supply of plant and machinery in reliance on a Chinese supplier. So there the liability, the price variation in respect of foreign euro. Then the domestic supplies, where it's in terms of rupees. The third is in terms of the stage when you come to testing and etc. So there, if there is any price variation, the price variation will fall. But then none of these formulas or terms relating to escalation, neither the escalation nor the formula are part of a contract. So if none of the formulas were part of a contract, the claimant picks up one particular formula in the course of its show me that. In the course of the rejoinder before, show me that particular
contract was for setting up and making operational a boiler.
Yes.
Thermal plant.
The whole plant.
That's the point.
It had 4 verticals.
So what I'm trying to say is in a case where the liability could have been fastened.
Thermal power plant. No, what
We'll make sufficient.
No, what was
I told you.
no, what was the manufacture to be done?
Show me
by
the
the
tribunal.
plant?
I don't want.
The boiler, the chimney, the turbine, and the MDCT.
Okay.
So these things, the boiler and
You
to come
touch him.
from
It's
I know, that's right.
I don't want to interrupt.
Like, for example, making steel or generating
generation of
the whole
electricity. For that you need
No.
demineralized water from a demineralized plant.
this is the
Water will
there
come, water will be heated with coal.
This is the
Coal supply in a boiler. It will go right to the demineralized plant, gets recirculated. Again, cooling tower to be constructed. It will be cooled, and then, my lord, the ash will go to a
combined thermal and hydroelectricity plant.
right entire combined thing.
Not hydro.
It's not hydro, thermal.
boiler is
Hydro is
Not hydro.
thermal is made out with coal.
I think we probably handed over this scheme
on the first day.
If it is not, please hand over.
So we had it. It's from Pratham day. Keep not
Is it a one sheet? Okay.
one sheet, which are
It has to be.
Important.
You have copies. It is your copy, is it?
yes, sir. I think.
No, listen. Not this. Wonderful.
I think this is the flow chart.
No, I think
Yes, this one.
The one sheet, that's right. It's a
Flowchart
schematic
project.
diagram.
Flow chart or project?
Yes, yes.
That side, that side. So we have 1, 2, 3. At the top, 1 and 2, coal handling plant. This was to be constructed by TRF, that is our subcontractor. Then water plant constructed by MBL. They're all under our responsibility. Then we have the main plant, item number 3. The main plant with ash handling plants. It's all to be constructed by RIL. And that consists of 5 segments. One is a boiler. Then from the boiler, we go to steam to the turbine. Then C is a cooling, natural draft cooling tower. And when then comes the gas plus ash. For that, we have the ESP and the gas chimney and the ash handling plant. For that constitutes a complete plant and machinery. So they were trying to point out that the agreement did not have any formula for the purpose of price variation.
Raghunathpur is in which district?
Purulia.
Raghunathpur is in which district?
Purulia.
Raghunathpur.
Purulia.
Purulia. Minute. Big Raghunathpur.
Purulia.
A lot of construction also going on. Minute. Raghunathpur.
So if the agreement did not have a price variation clause or a price variation formula to be applied, everybody went on the footing, I'll give you an extension of time. So it is kept aside completely for all practical purposes. I was trying to point out that the tribunal entered in, the threshold went on a wrong journey. Then at the end of the journey, it picks up this formula given to a rejoinder file before the tribunal. It says that I'll pick up one formula. That is the formula at page 100 and at page 30.
What formula was relied upon by the
Reliance says this is the formula which we universally follow. So I'm not getting into all those niceties of what statements, facts, etc. I'm only trying to raise a level of debate to a level where the question, if I've asked several wrong questions, but now I'm asking myself another wrong question, which formula will apply? So I am applying a formula chosen by so and so. So for, yes, sorry.
Formula CC2, page 32. There are 4 formulas. CC2, page 32. Page 32.
Show me that page where they say
308.
4,000 crores, therefore we can get the detail. Just show me that.
Yeah. 32. You see, this is universal formula.
Show me from the tribunal fine.
Yeah, tribunal is universal. This is 22.
Page 156. No, where is it?
See, indices, which is a part of the formula.
That's So I'm not requesting the court to get into the details of it because this is not a case where even the tribunal has gone into details. Because I understand, if I am not wrong, that when you apply a formula first, there has to be a fact, there has to be actual, something has to be proved. Every formula will have certain,
what was the
let's say
justification?
factors. So there is
How did Reliance justify for using this formula?
They simply say that this is a formula universally used by us. That's all this.
Used by them or
Used by them in their contract. Kindly turn to page 308 of CC 2. Page 308. Middle of that page, question number 19. My lords, have that page?
Yes.
On what basis have you applied the price variation formula based on the Indian indices to foreign supplies under the contract? The indices have to be applied as we would not know what would be the actual incremental cost in the foreign market. One has to do a guesswork there. Then question number 20. Is it correct that the calculation in affidavit is based on a hypothetical application of the formula for the foreign supply? Answer, no. To my understanding, the price variation formula is a universal formula. Completely evasive answer. Is a universal formula which we also use in other projects.
Question 20.
So this applies both to foreign as well as Indian supplies. Question 20. So we apply it in our own contract. Next question 21. In the exercise undertaken by you to make this calculation, have you verified as to whether the increased amount was paid by the claimant to the foreign suppliers? No. I have not verified it. Then again, next question. In the exercise undertaken by you to make calculation, I verified as to whether the increased amount claimed for domestic suppliers was actually paid by the claimant to various domestic suppliers? No. A clear case of no evidence. For the application of formula, firstly, I say it cannot be applied. Secondly, in order to be applied, you must have something to support the application.
Even if the arbitrator is not bound by the formula, arbitrator can pass an award which, according to the arbitrator, is just and reasonable.
Correct. Correct.
That
Provided. You'll also say absolutely right.
Supported by reasons.
Correct. Provided that stage of giving an award arises at all.
Yes.
The just and reasonable part of it can come when both parties have not enabled or facilitated the arbitrators to do that, then the court does some kind of a guesswork and say this is the amount. But that's on the foundation that, yes, I have found good reasons for giving a reasonable amount or a good and reasonable. But our case is that there are no reasons. There is no foundation made. We are not at the second stage. We are in the first stage. The second stage can happen only if the foundation is strong. If the foundation is seriously questionable, as what I call shocking the conscience of the court.
Foundation of a legal claim.
Absolutely. Now, for this aspect of the matter is a clear case of no evidence. And how does the tribunal look at it?
CC 5.
CC 5, page 156. Just make a note of a few paragraphs here. We have objected to the arbitrator's proceeding in this regard in paragraph F at page 156.
153.
156. The respondent has opposed these claims by submitting that the claimant has not adduced any evidence to show the actual loss, and the evidence of CW2 does not provide any details of actual loss suffered by the claimant. Therefore, the entire claim is based on a hypothetical calculation. Now, how does the tribunal deal with that? In this regard, we observe that it is a settled principle of law that when a contract has been broken, the party who suffers an occurrence breach is entitled to receive from the party who has caused the breach compensation of loss so caused by the amount. That is section 73 being reproduced. Paragraph G is nothing but section 73 being reproduced. Paragraph G at page 156. Then paragraph H. It's settled law. The Honorable Supreme Court that in dealing with the cases concerning the work contract, minute details of loss and damage did not be proved. Rather, a particular evaluation must be undertaken. According to the Honorable Supreme Court, an arbitral tribunal to make an assessment of what the damage and what with the quantum in respect of the same. So that's what you also put to me, a reasonable amount, a good and reasonable amount. But if there is no basis for that at all, the question of court going into that doesn't arise. But I go further in saying, even in that respect, have you done your job? If you can't do your job because there's no evidence to it, then in this case, can you do your guesswork? So therefore, the claimant cannot be treated in default for relying upon indices in computation of its claim, in our opinion. In a contract of this nature, where the value of the work runs into nearly 4,000 crores, it's nearly impossible to present records denoting each instance of escalation. In this particular case, where the prolongation of the contract was necessitated on account of inability of the respondent to provide inputs in right time, by virtue of the fact the respondent itself was not claimed delay in respect to so-and-so, and we having no delay is found on the part of the claimant in respect to Unit 2, we are unable to agree with the contention. These claims are causal, imaginary, and not based on fact, because in actual days, I find many things are so mixed up here. Yes. However, paragraph K. However, what does not escape our attention in regard is the fact this claim is premised on the basis of the bills raised by the claimant on the respondent after the scheduled date of completion, and applying the price variation formula thereupon. CW2 has deposed that the indices used to compute the amount representing the variation in the price taken from the Office of the Economic Advice so-and-so, and the base date for the variation considered in June 2009. I point out that page where he says, I have not done the calculation at all. I just point out the evidence of CW2. And that runs exactly counter to what the tribunal says.
He relied upon the reliance relied upon the CW2 evidence.
I showed that page, Your Lordship. 308. Just come back to that.
Yes,
Pointed questions.
19.
308.
19.
CC.
Question 19.
CC2.
Yes, 19 questions.
Yes. Question number 19, 20, 21.
We've got it, Mr.
That's right. Yes, therefore it's just to be kept in mind.
Another point.
So therefore, the tribunal now saying what? The tribunal is saying, now we go to where the 70% here. And to come to page 158. 157 bottom. Accordingly, paragraph N, accordingly we hold, claimant would be entitled to this claim. However, having regard to the relevant factors which have been brought to our attention during the course of the arbitral proceeding, we feel it appropriate to restrict that claim to under the head to rupees so-and-so, being 75% of the amount claimed under these heads. The aforesaid amount carrying interest. The readers of this award may question as to why we may have reduced the claim to 75%. As a objective reader of this award, I'm not talking about why you have reduced it. I say, why did you get this question at all? Then next, our decision to restrict this claim is premised on our discussion and finding on the issue of delay. And after examining the records as well as the arguments advanced, we are of the considerable view the claimants entitled to restricted 75%. So the question is, where is the discussion? Where is the finding? The delay must show in only one way. I can understand that 75%, 80%, 25%, then it's entirely in the domain of the arbitrators. But if the findings are illegal,
It's percentage of contribution with regard to delay.
Absolutely. Therefore, we go back again to the question as to how did the arbitral award start its journey. It commences journey by asking a wrong question. It went into wrong approaches. And then, therefore, patent illegality runs through the entire phase of the award. Now, let me take a lot completing at what the 34 court has done in this regard. Page 344. Number of judgments were stated on the question of formula. The discussion in this regard, kindly turn to page 338.
CC5.
CC5, 338. The discussion begins from this page.
338.
CC5.
Yeah, 338.
338.
Paragraph 18.1.
No, 338 of volume.
CC5.
Oh, CC.
CC5.
Oh, this is CC2.
I'm so sorry. The tribunal award and the 34 judgment. I don't propose to read it in extenso. Just make a note of these pages. 18.1, it begins. Then the court also notices, after the formula is set out, also notices at page 341, Page 341, the evidence given by CW2, lots of just seen, all those 18 to 22, etc. So 341 to 343, the evidence is noticed. Then at page 344, paragraph 18.4. In respect of the price variation formula, it is argued by the petitioner that the price variation formula has not been provided in the contract, and furthermore that the formula has not been unilaterally imposed on the petitioner, which is not permitted. In this regard, judgments of the Supreme Court in Sanyong, PSA, Universal Seaport rely upon by the petitioner. However, to mind these judgments do not help the petitioner's case. When there was no specific price variation formula provided in the contract, and the respondent was entitled to damages, there had to be some formula applied to quantify the amount of damages. In such a situation, use of a universal formula, which has been also used in other projects, cannot be termed as perverse or unreasonable. Moreover, CW's examination and further evidence in regard has been thoroughly taken into account by the arbitral tribunal. The Section 34 Court looks into this evidence at page 340, 41, 42. Where is the evidence? When asked question, where is the evidence to show that there is a basis made for applying any formula at all? So the ipsy-dixy of the claimant saying that this formula can be applied, regardless of the fact that this formula's application on facts is not made out. The evidence does not show that. So then the tribunal Section 34 Court says there has to be some formula. I wonder when the contract forbids a formula, the tribunal finding forbids any further inquiry as to whether delay and apportionment can be found out or not. In that situation, will you hunt for a formula? So my understanding is hunting for a formula on the basis of the formula being placed itself is patently illegal. The formula could not have figured in the reasoning of the tribunal at all. That could have figured only if on the other aspect of the matter, namely some delay, some obligation not being discharged, etc., then one can say, look here, I'll do a second bill. If there's no formula, I'll find some formula. I can understand that.
Yes, that is one aspect that the tribunal has gone wrong in not apportioning the delay and the latches.
That's true.
And thereafter. So, if it is accepted that the tribunal has not erred,
yes,
then formula can be accepted. If we come to the findings that there is no error on the part of the tribunal.
That's true. But that's why I'm saying this is a case where the room or the occasion for the invocation of the formula itself doesn't arise. The court says some formula has to be applied. You can't.
Formula is just a guideline.
Absolutely.
Not statutory any rules.
Correct. When there is no statutory framework, well, I have a formula. These are all time-tested formulas. I'm not getting into the formula at all.
Yes.
The whole construction industry has built it over a long period of time, gestation. I'm not getting into them. My question is, no specific price variation formula. There had to be some formula applied. It proceeds on the wrong premise that regardless of the price variation, absence of it, because the tribunal has held that there is some delay on the part of so-and-so, some formula had to be applied. What is wrong with formula A or formula B being applied? Don't get into that question at all. I say this question is wrong. Because that question of asking for a formula or a choice of a formula can arise only if there is a ground made out to reach that stage. Reaching that stage had not happened at all. Therefore, there is a twin error in this. One, picking up a formula which is not anywhere, and the application of formula which is without evidence. That's a glaring aspect. It certainly shocks the conscience of the court. So no evidence at all. So would I be satisfied if instead of 75%, the tribunal had given 10%? The answer is no. It's not a question of the quantum. I am now agreed by the fact that DVC is fastened with a liability. I carry the tag on my back. Why should I carry the tag on my back? The liability tag is staring at me. I am not concerned about, particularly about the quantum, I say. So question we ask, suppose if the tribunal is given 50%, 30%, would you have agreed? I don't know about that. Why should I do a guesswork? So that's not the question. So therefore, this para 18.4 is a patent illegality on the part of section 34 code. You want to just...
It's just from partly there. It's the last.
Yeah, where is that? For the code?
I can show it from. It's in our compilation of page 5.
Where is that?
530.
There's only two paragraphs.
See, but facts have to exist for application of
Paragraph I read it. In this case. Yeah.
Yes. Please get that.
It's not there in the compilation of that.
Source copy है.
Right.
Partly board.
Battle board.
So show it from source.
Paragraph 15.
Yes. Computation
Just see, kindly turn to paragraph 15 of this judgment. The Supreme Court dealt with a question of application of some formula. Just above paragraph 15, we'll also turn to
is from internal.
I know.
What is the page number of 539?
Paragraph 14 is extract from McDermott International case. And just above paragraph 15, para 107 from McDermott, this is how it reads. Is the learner arbitrator, therefore applied the Emden formula in assessing the amount of damages, he cannot be said to have committed an error warranting interference by this court. And that was a case where I say there was no other disabling factor which could have come against the arbitral tribunal applying a particular formula. Now I read paragraph 15. McDermott suffers so and so and so. 55 and 73, we deal with the effect of failure to perform at a fixed time in contracts where time is of essence, and computation of damages caused by breach of contract respectively, and states that these sections neither lay down the mode or how and what manner computation of damages for compensation has to be made. As computation depends upon attendant facts and circumstances and methods to compute damages, how the quantum therefore should be determined is a matter which would fall within the domain and decision of the arbitrator. This is without doubt a sound and legal correct proposition. However, the computation of damages should not be whimsical and absurd, resulting in a windfall and bounty for one party at the expense of the other. The computation of damages should not be disingenuous. The damages should commensurate with the loss sustained. In a claim for a loss on account of delay in the work attributable to the employer, the contractor is entitled to the loss sustained by the breach of contract to the extent and so far as money can compensate. The parties should be placed in the same situation of the damages as if the contract had been performed. The principle is that the sum of money awarded to the party who has suffered injury should be the same quantum as she would have earned or made if she had not sustained the wrong for which she is getting compensated. Now, paragraph 17, we shall subsequently catechize the Hudson's formula. Sufficient notice at this stage that the learner arbitrator does not specifically refer to any formula or the method and the figures to compute damages and they had a loss on account of overheads. The award refers sections 55 and 73.
Your case is there was no ground for application of the formula.
That's my case.
And secondly, the application of the formula was arbitrary.
Was arbitrary for an important reason that there is no evidence.
Without any basis.
That's right.
Okay.
Let's just make a note of paragraph 21 of the judgment, and I would have done with it. Paragraph 21.
Paragraph numbers in the data.
Yeah. Paragraph 21.
21.
21. 21 and 22. I don't see one that's all. No, that passed on 21. The conclusion. No, that's okay.
Presumption should be examined in satisfaction of presumption resulting in the facts and circumstances.
What is it?
Okay, we'll give the paragraph numbers. We had only listed these, but we are deleting this.
Yes.
So we only show what we do.
Yes, shown it.
Yes, you've shown this. On rewriting the terms of the contract, we had Sangyong because formula is not there in the contract. They have rewritten the terms of the contract.
What I will do is that the Lordships know by heart Sangyong. So we will put in a note. It says Sangyong says this. So what has the arbitral tribunal gone wrong, right, in the face of Sangyong? So we will put in a small note, and so that we don't have trouble reading. Because there is always a temptation.
And whenever you feel like when the matter goes on, you can come online. And
Of course.
add.
If I'm able to come,
You
quickly,
will
I'll try to
come,
come.
or you can add online also.
Very well. So I just want to say this because there is always a temptation, say that a recent judgment says so, right? The DMRC judgments. There's a lot of good deal of talk about it in both sides. So it has virtually driven a what's called a nail on the coffins of good arbitration procedures. Why should Supreme Court 142 curative? So it's going to send the wrong message. On the other hand, there are the people who think that the process of arbitration, in order that it is sane, acceptable, and reasonable, and does not shock the conscience of the court, this is a message which the ultimate court will necessarily send. So therefore, two ways of looking at it. So DMRC, since I had appealed in this matter, we spent a lot of time thinking whether the Supreme Court's curative jurisdiction, which is the final armor in the clink of a client, should it be invoked at all? A lot of application of mind went into that. Both my predecessor, Mr. Venugopal, Krishan's father, we spent a good deal of time on reflecting on that. But we found that there's something which shocked the conscience of the court. A 34 court it did not interfere. A 37 court interfered in the matter. And the Supreme Court said, no, we don't agree with you. And when a basic, or what called the reliance failure to perform a contract in a particular way and wanting to run out of it by finding an excuse, because ultimately we saw this is something which is a miscarriage of justice. So in Hura, we talk about miscarriage of justice. Therefore, we're all talking about shocking the conscience of the court, patent illegality, even though they are couched in very, very broad terms in Section 34. So the miscarriage of justice principle is what will probably appeal to the court. They're all put together. The court feels here is a miscarriage because we are not convinced. The two courts below have failed to apply or have not applied something which ought to have been done. Therefore, the conscience of the court and the miscarriage of justice is something which overlap. So having said that, I'm grateful for the court for my...
Thank you.
And I'll put in a note, yes. And whenever your lordships are subject to Leonard Trend.
And would you be...
The rest of it only...
Would you be joining us to give you a reply after the...
Yes. We'll do that.
They have a cross appeal.
Oh, they have a cross appeal also.
When would it be convenient for you?
Well, would it be possible on Thursday? Next Thursday?
Thursday, one half would be all right. Second half?
It will take a little longer.
No, you might take, but if we allot one half and then the following...
Very well, Manoj. If it could be the entire afternoon session or the morning session, I think... oh, I see. I am entirely in my Lord's hands.
No, you. How much time you are likely to take?
Not more than 2.5 to 3 hours at the outside.
So if it is 2 half days, it is all right.
I believe so, Manoj. More than enough.
So one the coming week and the other the following week. Would that be all right?
Very well, Manoj. Most grateful.
এই নগেন বাবু এই ক্লিনিক স্ট্র্যাটেজিটা দেখুন আপনার বৃহস্পতিবার দুটোর সময় আমরা কিনি
Third. The coming Thursday. Second.
Thursday at 2 p.m.
Most grateful, Manoj.
Yes, please take down.
That will see.
Learned Attorney General concludes his arguments. List. List this appeal. Let's check out. This appeal on second May, marked at 2 p.m. to hear further arguments on behalf of KFL. Second May, marked at 2 p.m.
Most grateful. Most grateful.
Huh? Exactly. To hear further arguments on behalf of the appellant Damodar Valley Corporation. On behalf of them. Okay. Appeals.
Grateful.
So once water.
Yeah, fresh water. Andar, iske andar.
Yeah. This is what heard.
This is fresh, sir.
That's okay. I heard.
Yeah,
Anyway, I think we made all the points that we had to make. So, all the points that we had to make.